Live. Okay, thanks. Okay, welcome everyone to tonight's meeting. We're going to go ahead and start the meeting with the Pledge of Allegiance. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. So, going to go ahead and start with our roll call. I'll start with you, Rick, since you're on Zoom.
Here.
Rick Hardy.
Okay.
David Shuey.
Julie Johnson.
Randy Wise. Brett Townsend, Board Attorney.
Okay, and also we have our town manager, Mr. Zolper, as well as Mr. Dedes. So we have our only member missing is Dave Vogt, who is MIA, but that's okay. We have a quorum since we have 3 members in person and Rick over there on Zoom. So the first item is to adopt the agenda. Did everyone have an opportunity to look at the agenda?
Yes.
And do I have a motion to approve?
A motion to approve.
Second. All in favor?
Aye.
Okay. So the agenda has been adopted. The first item, as far as a public hearing, is for 4 C Strand Court, Unit 10. It's a request for variance of the Code of Town of Dewey Beach to add a half-story to a non-conforming townhome with party walls extended into the required 8-foot side yard setback. The request has been submitted by Tina Hall and Stanley Hall. Is it Hall or Holly? Hall. Companies. So, see, like, is Sally here? Oh, okay. We're gonna have you come up and present your request for the variance. Mr. Townsend's gonna swear you in, and then you can present what you want to send to the board. Fred?
Name and address for the record, please.
Yes, my name is Alan Halley. I reside at 36831 Janigan Drive, Frankfort, Delaware.
Sir, do you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
You may proceed.
Yes, we have a townhome in which the residents and owners thereof are looking to do some modifications. We're adding a half-story proposing to add a half-story to the townhome. The nature of the community therein is not being affected by this. There are many homes in the community that have already done this particular renovation. As a matter of fact, we've actually copied one of them so that to make sure that we were in compliance with what we thought was necessary in the community. So the character of the immediate vicinity will not be affected. The neighbors, if this is granted, will not be impeded. It does not do anything to their vision of the beach or the ocean or anything of that nature. The purpose for the unit being expanded in this way is there you have a growing family, adult children, grandchildren, etc. So they want to improve the building by adding the half story. It does add square footage and allows them to have another bedroom in the unit. So this isn't an ego build, let's call it. You know, this is something that is needed. And if we don't get granted the exception, it does impede, you know, their full use of the unit, you know, as the family comes down. There is many precedents for this expansion. I think it's a total of 10 units that have been modified in these directions within the several buildings that reside in the community.
And we've seen several of these, obviously, so we're very familiar with C Strand right now. So I think we kind of understand what the idea is here. Does anyone, do you have anything else?
As you're looking at the pictures, we are going to mimic this top picture here of the building, and then the unit itself is the third one in from the left on the bottom picture.
Okay.
Okay.
Any questions?
Basically
popping out a big dormer.
Correct.
Got-
Yeah, we're doing a shed roof dormer basically out of the rear, cleaning up the front with some metal roofs and, putting in new decking and prettying up the whole building. It's a little bit old.
And obviously with it being a townhouse, the setbacks aren't possible, given that it's a townhouse. and you have the
Correct.
walls on the
There is no way around this.
Right, okay, so, Rick, do you have any questions?
Just one, and this is kind of one we always ask, I think, but just the amount of square footage that you're adding with this third floor, or how?
The third floor adds about 600 square feet.
Okay. And then that brings our total to
To be honest,
1,600 or something.
something around there.
Okay.
And these
It's
are,
pretty modest.
And we're adding one bath and a bedroom to the third floor with a small deck.
Right. Okay.
And it's not expanding any of the footprint of the unit.
right,
Okay.
That was my question as well, just if you could elaborate at all on the size of the unit presently and what difficulties that size presents, how it might compare to a unit that would be built today.
Yeah, so the unit itself is 2 stories with 2 bedrooms and 2 baths, with a small kitchen down below and a small family room. So it really hinders space for today's modern family in that direction. And by doing this, will allow basically a owner suite upstairs and allow them to live upstairs. And then the children, grandchildren will be able to take over the 2 bedrooms that are down below. So it adds a 3rd bedroom and a bath for
And
convenience.
the
purposes.
unit is still going to be less than 2,000 square feet?
Yes.
Yes, okay.
It seems at 600 square feet, you're only getting 1 bedroom and a bath out of that?
Well, it's a generous, it's.
I'm just curious.
Yeah, so, it's a bedroom with a sitting area and a bath. And then the other square footage is basically, you're expanding out over an existing deck. And we're leaving half of it open as per that one picture. And the other was a sitting area to look at
That's a nice area.
the water. Yeah, it'll be pretty.
any other questions? Is there anyone who would like to speak either for or against? Let's at least start in favor of the variance. Is anyone here that would like, okay, I don't see anybody online for this one, Kate?
I'm speaking up.
Okay, anyone who would like to speak against us granting this variance?
Could you pull the microphone a little closer?
Oh, okay, sorry.
So the audience was invited to speak either in favor of or in opposition to the application.
I don't see no one here in the audience in person. I don't see anyone. Kate, does anyone let you know? Okay. So I'm going to go ahead and close the public hearing. And the board, you can have a seat, sir. Thank you.
Thank you.
The board will discuss the application. Fred, just because
Yep.
it's been a while since we've had a meeting, can we go over, and since we have 3 applications tonight, can we just go over the
Sure.
factors again, just so that we're all refreshed?
Very good, and the prior, or the present applicant has apparently done some research because he did hit on all 4 standards, so he must have paid attention to a prior, hearing. The first consideration for you is whether the proposed variance would create an inconsistency with the current zoning district, or what the zoning district allows for. It's a residential zone. There's no change to the zoning that's proposed as a result of the granting of the variance. The second consideration is the character of the immediate vicinity. And we have a really well-established character in this case. We've got a series of complexes of units in the vicinity of this unit. And then third, we have impact on neighbors. That was discussed by the applicant, whether there would be any impact on the neighbors. And in the context of impact, sometimes there's a weighing test that's applied. does the impact on the neighbor outweigh the impact on the owner if the owner is not permitted the variance that they're seeking, or the relief from the restrictions of the code? And finally, the fourth consideration is whether the applicant's confronted with an exceptional practical difficulty in relation to his efforts to make normal improvements to the property.
Okay.
So there you're looking at whether it's a significant difficulty, whether the applicant is seeking more than is necessary to relieve the difficulty, and I can answer questions you have in that regard.
And I think I heard the applicant say one thing that I want to clarify. It made a comment about precedent, and I want to be clear that this is not, we are not a precedent-setting board. We look at every application case by case. I know we've had applications like this in the past, so to some extent, it's easy to get caught that it's a precedent, but I just want to be clear, that's a big word, a big legal word that I don't want us to go down that rabbit hole. So anyway, having said that, any comments? Yeah, okay, any comments?
No, it's pretty clean.
Rick, any
Good.
comments?
No, I'm good.
Okay, do I have a motion?
Can we move to accept the variance,
Yes.
grant the variance?
Yes, can move to do that, for any further reasons.
For the reasons that are set out, it's consistent with the district and the character of the vicinity, and there is no or minimal impact on neighbors, and it would present a practical difficulty if they were not able to make this expansion.
Okay, do I have a second?
Second.
Yep.
Okay, all in, for the same reasons?
Exactly.
Okay.
So well spoken.
And we're gonna do a roll call vote. Rick,
Approve. Aye.
for the same reasons
For
stated,
the same reason stated.
Aye,
since it's your
for
motion.
the
I
same
guess.
reasons that I've given.
Aye, for the same reasons given.
And I agree, I also vote in favor of. So that is passed unanimously. And thank you.
Thank you all.
For being here.
Appreciate it.
This next application involves an appeal, and for that reason, I have arranged for Diana Stewart, an attorney at Smittinger and Rodriguez, to substitute for me, and I will present the appeal portion for the town. So, Ms. Stewart.
And bear with us while we. So how do you want to do this?
So, Mr. Dukes and I have spoken, and it's typical for the appellant to go first,
Okay,
and then we'll hear from the town, and then we'll hear Mr. Dukes again on behalf of his appellant. Both parties, the town and the applicant, will present some witness testimony, and then you will also ask for any comments from the public.
okay, this is the first
Okay, yeah.
type of hearing that, like this that I've done. Okay, so this is item 2 on the agenda, or actually technically item 3, is the open public hearing 2 for 203 Carolina Street. It's a request for a variance to the code of the town of Dewey Beach to permit the reconstruction of a previously non-conforming residential structure that has been demolished, utilizing the existing foundation, including construction of the west wall extending 1.8 feet into the required 8-foot side yard setback, and a request for an appeal from the building official's interpretation of that section of the code does not permit the rebuilding of a non-conforming dwelling that has been demolished by the intentional actions of a contractor. The requests have been submitted by Jason, I'm sorry if I'm butchering that, I know, of Sewell Design Build. And Mr. Dukes, you're ready to
evening.
get started.
My name is Hal Dukes from the law firm of Tunnel and Razor. I'm here on behalf of Durrell and Carol O'Connor. 203 Carolina Street, it's zoned NR zoning. In the process of doing renovations, it was decided that a portion of the wall should be kept in order to basically confirm the fact that the encroachment is allowed within the parameters of the code. In that regard, the contractor, Jason of Swell Design Build Company, is here to tell you about exactly what happened. It was an accident, and the wall itself collapsed. And what the original thoughts were that they'd be in a position to go ahead and say, well, it was an accident and continue building, but it didn't work that way. And so we had this appeal. Now, I will say this. If, and I know that your time's precious, if this appeal isn't appropriate, we are also applying for a variance. And we have consent from the neighborhood and the neighbors. And in my heart, I think that the variance is probably something that would be very seriously considered by this board in a favorable light. So whatever you want, whether you want to do the appeal, the appeal, though, is focused most on the facts of what happened. And Jason as well is already sent you, I think he sent you a report on exactly what happened with pictures and everything. But for purposes of formality, I'm going to ask Mr. Jason come up, please. And then he can go ahead and go over the details of the accident. You have to be sworn in.
Okay. Can you state your name and address for the record, please?
Yeah, Jason Kenya, 33960 Sea Otter Way, Millsboro, Delaware,
And do you-
19966.
Do you swear or affirm that the testimony you're about to give is the whole truth, the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
Okay, so we had started this process with the owners about a year ago to create an addition, if you'll notice, which says proposed addition on the rear of the property, which is the north side and the east side. This is to create a little bit more space in the home. It's approximately 450 square feet that we're adding, 467 square feet that we're adding to the house. Included in this renovation was also or in these additions were also the renovation of the existing home as well. So in November, submitting a permit application, which you'll see here with the plans, we had planned to raise the roof of the house and just create the extension out the rear. That included the rebuilding of the west-hand wall, which is a non-conforming wall. And you can see this is highlighted on the left-hand side. There's a portion of that wall that's non-conforming. The rebuild of that was going to go from their 7'11" ceiling height to a 9-foot ceiling height. And that's been marked here, as well as removal. If you look on the right-hand side, that says clearly marked to be removed. That was the existing foundation, which was already conforming. The whole rear and the right-hand side was conforming. During demolition of the right-hand side and the rear of the property, which I had requested to, and actually sent an email to Jim Dedes of, as well, saying that I needed to take a tree down, to get an excavator in, to remove a propane tank on the east side of the home in the rear, that we were also going to use that excavator to remove the block wall in that right-hand section. While the excavator was on site, he had gotten his claw of his excavator stuck in the rubber membrane roof, which apparently has a bunch of concrete and mesh and concrete in it, and could not get this removed. In terms of him pulling on this, there's a masonry fireplace on the west-hand side of the wall next to the non-conforming wall. And this structure, just in an instant, it started to collapse. Luckily, we don't have guys on site or in the structure when we are there, but this fell flat, literally in an instant, just fell down. At that point, we decided to, and I felt it was prudent to remove what was there, remove the floor system. You can see in Exhibit B2 here that just collapsed flat. Exhibit B1 was just a moment before that fell. We do record everything when we're, on site. We've got a camera set up in the back for time lapse. We set up in the front of the property as well. So due to the weight of this that fell, we cleaned everything up and felt it was prudent to make sure there were no damage to the existing foundation, no damage to the floor joists. as I understand, that it was probably our duty at that point to stop and call the town and say, hey, this wall came down, what do we do? We did not do that. We cleaned everything up. We assessed the space, and we're left with the existing hole in the ground. Now, we have continued on with the addition and the right hand, all the conforming walls to create the new addition to the home. And we're just asking for some relief to that zoning ordinance that says that and we have a couple of things going on. She's moving fairly quickly here, but that west hand wall that's been in place, it's been in place there for 60 years. And I think the interpretation of the code is that if the wall is destroyed and it says a non-intentional act of an owner, that it shall be permitted to be rebuilt, a non-conforming structure in the same position as prior. I think the town is stating that we had intentionally demoed in some effort to gain some advantage here, which I can clearly tell you that was not the case. That was not our contract with the owners, and this is costing quite a bit of money for me to remedy. This is not advantageous to us in any shape, way, or form, but I do think that that code in a NR zone here, I think that code really is geared over the years, as I've seen the changes and addendums to that for the flood zone areas was definitely meant that those areas to be not rebuilt in the same position, for them to be rebuilt raised to current FEMA codes. What we are requesting is that we are able to rebuild this wall in the same position, utilizing the same foundation as the approved plans were, considering that the wall was going to be raised 1 foot anyways on that side and rebuilt. We were going to have to rebuild it stick by stick. Now we have to rebuild it just the way it is. We already have a set of plans here from the county, which they've looked at the new footings, they've looked at this structure, and they've said that this is still considered an addition, that there is a portion of the existing foundation, just as what's drawn on the plans exactly remains as what is on the plans. So there are some factors here that we're looking at. If you scroll down here, if we are for some reason meant to move these walls, there are a couple of hardships here. If we're meant to move the west wall, you can see the large trees on the left-hand side of the property, and also on the right-hand side of the property on the adjacent owners' properties have large root systems. If we are to start continually digging, we are going to disturb those root systems and potentially have 1, 2, 3 large pine trees, which have been there for probably about 100 years, be damaged or removed. The adjacent owners, I believe, do not want those trees to go. In addition, there are a number, if you scroll down as well, there are a number of non-conforming structures, which are all the neighboring properties. I don't say all of the neighboring properties. The 3 adjacent properties have non-conforming structures on them. And we are not asking to move this west wall any closer to the existing west neighbor. There is not a structure on her property. She had renovated, in fact, we had renovated the neighbor's property on the west last year successfully, and they don't have any plans, I don't believe, to build close to that west hand non-conforming wall. So I would just ask that, in closing, that we take a look at this from a reasonable standpoint. We have letters of support from, I believe, 7 neighbors who have all stated that they're looking forward to seeing the house being rebuilt. We would like to rebuild it to the position that it was in, to the position that was approved by the town previously, and not, this is not something that we're looking to gain some type of oddity, advantage, I guess, as opposed to what was there previously. So I would just ask for that consideration, that you take a look at the age of the home and the support that we have here, and I think think that's where we're at.
Do you have any questions of?
That was a question. Was, when you got the first permit to do this project, and then you had the accidental demolition, we'll call it, was there any evidence that that was intentional? For the town to put a stop order, and you think they'd have to have evidence that was an intentional act?
Sure. I don't believe that there was. We didn't get that notation, but the evidence was there is no floor system left, right? Like you removed the entire floor system. And why did we do that?
Not for safety reasons.
So that is, and it was. I mean, I made a judgment call. We had dumpsters on site already. Made a judgment call. Well, we needed to remove these floor joists. We need to make sure that there was a huge masonry fireplace that came down and crashed down along with all the weight of the concrete on the roof. So we had floor joists that were broken 2x12 floor joists, which had been there for 60 years, that were splintered. We took things apart. We made sure that the west wall was intact, that the masonry was all intact, that we dug down and made sure that the existing footers are in place. And I think just, again, when you drive up to a site and expect to see a portion of a wall and there's nothing, there's a hole in the ground, they said, whoa, hey, we need to stop this. So I can understand that, but we're asking for some.
I mean, in the time when they put the stop order in until January, February, was there any investigations to make sure this is the way it happened? And or I don't know. It just seems like they're caught up in some bureaucracy here. Started out as an addition, had an accident, and now all of a sudden the demo was not licensed or permitted, and just stop what you're doing. It seems like a pretty drastic call. I mean, I'm going to just throw my opinion out there.
Well, it is, and it seems like that way to me as well. I mean, each step of the way, I've let the town know that where we're at, this was permitted to be rebuilt in the same position that it is, that it was an accident, and that, I feel like we're kind of being penalized a little bit for this. We were in touch every step of the way via email, and as well as phone calls trying to resolve this. And I do believe that because, Dawn Hanks was the one who approved this and had reviewed it. And as I understand from Jim and Bill both, that there was nobody in the official building inspector capacity to say, yes, this is our official answer, that we are in need of a variance for this or an appeal, that they were not the appropriate people to make the decision, that the town attorney would have to weigh in, and that we would need a general quorum here to decide what was appropriate here. Should this be allowed to be rebuilt or should it not? And unfortunately, we've ordered, floor joists, trusses, cabinets, everything for this property, because when we started in November, we were going to have them finished by June. And that's a 6-month build for a single-story home here. Just not looking to do anything drastic, not looking to add second story and change the face here. We want to really retain the character of the neighborhood and just get them a new updated place that was safe to use. Kind of turned into something else very quickly. So there was not a long period of time that this happened between when it collapsed and when the stop work order was placed. I think it was 2 days or 3 days as it was being cleaned up. So we've followed that stop work order. We haven't done anything, and we've requested each step of the way to try to resolve this, and it's led us to today's date.
Rick, do you have any questions for them?
Yeah, I do. Just a couple things, because I was actually nearby walking my dogs during this Sunday when you guys were doing this construction work. And I was curious, why did you erect the 2 cornered walls on the southwest end when the roof came down?
So a couple of reasons. One is just so we could have some place. We've got equipment on site, trash cans, miscellaneous materials, just something so we put a wall back up on the existing floor system that was there. We left a portion of that floor system that was not damaged by the concrete fireplace that fell, which is further back, and the roof system itself. So we just put that up to basically, hide, we have trash cans on site, things like that, things of that nature.
I never saw anything. I was curious why all of a sudden new plywood went up and you erected 2 corners.
I tried to put I tried to put the wall back up, but the wall is not, it's heavy and it's not going back up in place. So we had plenty of extra materials, and it's just something to keep some place to store things, essentially.
Gotcha. And then on the west wall, you said you didn't demo any more of that original footer, but it looks like you've replaced it or built on top of it based on your picture. Sorry, I couldn't be there today, but is that correct? Did you dig out the old concrete block and then just put new ones on top of the old footers, or how did that work?
No, that whole west wall is existing still. So we haven't touched anything on that west wall itself.
Okay. Yeah. In
It's
your
only the
pictures, they
rear.
look like new. They look like new bricks and concrete holding them up.
No, not at all.
Okay.
In the north side and the east side, which was permitted, and I believe we have an email from Jim to go ahead and that were permissible to continue those. I don't know if you've got that photo. There you
Yeah,
go.
there's another
So-
one that you guys have that shows more of the west wall as well.
So on the left,
That's
on
the
the
east
west
wall.
wall, that's a 4-foot wall, and only 2 feet of that wall is continuous. I don't have.
Okay.
If you look at the.
There's another one in your diagram, yeah, that shows more of the west wall, but it looks like brand new concrete. So I'm like, if you were to demo that and then, just put in new footers, you're also this wall right here.
Yeah, that's not
sorry,
new
my-
at all. That's all
It's not.
existing, and it's, the existing footers, existing walls, et cetera, mortar, all that. And we did have a structural engineer come out and take a look and make sure that those footings are verified to size, so on and so forth, to continue
Okay.
on the plans that were built.
Gotcha. Yeah, in your other picture, it looks like brand new cinder blocks. So I'm like, okay, if it wasn't demoed, it looks like we
No.
added cinder block to it.
No, sir.
That whole cleanup process, I'll tell you, went pretty quick. You guys had dumpsters all there to take it all out. I was like, what's going on here on a Sunday?
I don't know that was on a Sunday when we pulled we didn't have dumpsters on a Sunday, but because the dump companies don't run, but whether it was a Monday or a Friday, whatever it was, we do have great relationships with all of our vendors. So I've got, major projects going on, and we also have a couple of guys that we called in with dump trucks to help clean up. I mean, we felt that was the best thing to do at that point to assess the damage and also minimize the amount of pollution, right? We put silt fence up real quick and make sure that you don't leave a site with a bunch of trash that can rain. I see some of these sites, like when the homes have a fire or something and there's no silt fence around a home that sits there and all those chemicals leaking all over town. We just try to mitigate that as best as possible. It was a judgment call, and I guess, again, an expensive learning lesson for me, considering this will cost quite a bit to put it back.
I'm sure.
Yeah.
Do you have any questions?
Okay.
Okay. So, anything else you want to add, and we'll let.
No, I think that this is appropriate. I guess you had some questions. This is the end of our presentation. I think that you're clear with some questions.
You'll get an opportunity to take the stand act.
Okay. Thank you.
Thank you.
For the record, I'm Fred Townsend of Hudson Jones, J. Work and Fisher, and the solicitor for the town of Dewey Beach. Thank you for your time and attention. And I'd like to start with the next slide, please. So just as a reminder, this is not, at least the appeal part of this is not subject to the considerations that you applied in the last application, which was for a variance. This application does involve a variance as an alternate to the appeal. So if the appeal is unsuccessful, you will be asked to apply the exceptional practical difficulty test to that application. But in this circumstance, you have the powers that are expressed in 18566 on your screen, and that's to hear and decide appeals where it's alleged that there is an error of any order, judgment, decision, determination, and the like made by an administrative official in the enforcement of this chapter. So in so doing, you are actually authorized to step into the shoes of the building official and render the decision that you think is appropriate given the evidence in the record. So you're not to defer to the town in this regard. You're not to say the town knows best, because the town does this every day. You are to make a determination of your own, whether or not the code was interpreted correctly. And the code provision that was interpreted by the administration to halt the further construction of the property is this provision here at 18559. Damage or destruction of a non-conforming use or building. So this building, and we'll see in a later image, and I think we got a glimpse of it before, is a legal non-conforming structure, or was, in that on its west side, I believe it was 1.8 feet too close to the side yard. So that's what makes it a legal non-conforming building. Were it built entirely within the building envelope, then it could be rebuilt in that building envelope without a variance. So what happened here is that there is a second window or second kind of exception that applies for legal non-conforming buildings that come down, if they come down as a result of damage by fire, storm, infestation, or other peril not caused intentionally by the property owner. So how that is interpreted is not whether the property owner intended for the damage to occur, but whether the property owner intended to do the acts that resulted in the damage. So it's a legal concept that that is analogous to intentionally throwing a rock into a crowd of people. You might not intend for any particular person to suffer harm as a result of that, but your act of throwing the rock into the crowd was an intentional act, and that makes you liable for intentional conduct. Here, the only appropriate way to interpret this language, in our opinion, is that the types of perils that can allow for a legal non-conforming building to be rebuilt are fire, storm, infestation, or others not caused intentionally. And in this case, the property is being renovated. It wasn't accidental that there was a construction activity on the site. The construction activity was intentional, and it ultimately resulted in damage to the property, as the applicant has said. But it's not the kind of damage that the town can then say, you're free to rebuild in a non-conforming fashion. In applying this standard, once the property is taken down to this extent, it is no longer legal non-conforming and must be rebuilt in a conforming fashion. So that's the rub that we have in this case. That's why the stop work order was issued, and that's why we couldn't authorize without a variance the building to be rebuilt in its old location. So here is another image of the survey, and on the left-hand side, you see a 8-foot dimension that runs, thank you, from the property line to the BSL line, which is the setback line that the property didn't observe in its old condition. And to rebuild without having lost the property as a result of an appropriate peril, the property has to be built within the setbacks, and it's not. That's not what the applicant is intending to do, and that's why the stop work order was issued. If we turn to the next page, at this point, I would ask for Mr. Dedes, who has knowledge of these documents, to explain briefly what they are. Mr. Dedes, can you tell us what that next document is?
The document you're looking at is an application for a permit. And that was submitted to Ms. Hanks back in November 13th. It was given to us at the town hall, and we turned in, meaning the building department, accepted the application, and Dawn reviewed the application and made some decisions that this was okay to proceed. Now, if you look at the application says specifically to add a 7x16 wall in addition on that side, and that's what, and the pictures that you saw earlier by Jason reflect that was a wall that we allowed, and he was allowed to continue building that wall.
Yeah, so which side of the property is that
That
wall?
would be on the west side of the property, east side of the property.
East side of the property, so that's the
correct.
conforming portion of
And
the
and
structure.
just so you know, and that, for the general dimensions, on the west side, they have about close to 12 feet, if not more than that. So they're well within conforming. Okay, they were also applied to build an addition for 16 by 25 feet on the rear of the existing house. So that would be on the north side of the house, and that meets all of the town setbacks. That was approved. And what also he applied for was to renovate 2 bathrooms, a kitchen, electric, HVAC, plumbing, flooring, siding, and roofing. So I recall that Jason and I had some discussions before he went into this, and I said, just be careful about construction in there, because, you know, that could cause some problems if everything collapses. Well, unfortunately, it did. So,
Okay,
one,
so Mr. Dedes, that document is signed by the applicant, is that
that
right?
is signed by Mr. Kania and on behalf of Mr. O'Connor. Mr. and Mrs. O'Connor.
Okay, and then if we flip to the next page, what do we have there?
What you have on the next page is what the town requires and the county requires is, once the application is approved by us, we move on and we do a referral to the county. And the county is responsible for doing not zoning, that's our responsibility, but theirs is to actually make sure that the building is built correctly, and they do. So they look at the building plans and look at what the types of structure and the type of work that they're doing, and they then will decide whether it's appropriate, make some changes. If there are changes made, it comes back to us, we review it to see it doesn't interfere with zoning. But for the most part, they approve it, and they did. And they issued a building license.
So the scope of work is described by hand there, is that right?
That is correct.
And does that not mirror, that mirrors the application
It
language?
mirrors the application, yes.
Okay, and what do we have next?
What you have next is I'm looking at this and I'm trying to track it. That is the actual permit that was issued by the town, by the county. And it basically regurgitates what we sent over there. And then they have a code that says, which is WBC. I don't know if you can see that on the, I think if you look up here, it's right there, WBC. And
You
that
do have a
means-
hard copy there,
Yeah, I
Jim,
have a
if you
hard
want.
copy, but I just wanted to point it out. And what that means is with building code, which means that the county is going to come in and do an inspection while they're doing construction. And they would have to issue potentially a final CO once it's completed. Now that they've done that, it comes back to the town, and the town will go to this level, and that's a county permit, a town permit, excuse me. And that is the permit that was issued. I signed off on behalf of Dawn. She was getting ready to leave the town, and she was very overwhelmed. So she said, would you sign off on it? Which we do that all the time. So we signed out, and a permit was issued for building the addition and doing renovation.
And the description of the permitted work is again identical to what was applied
It's
for?
identical, and along with all this, there is, with the applications submitted, there's a contract that's submitted by the builder and specifying the type of work that they were going to do.
Okay, could we flip to the next slide, please? Okay, so can you describe, first of all, do you know where that picture, or who took that picture, or how you came to be in possession of that picture?
I believe Mr. Zolper and I both went out right after I issued the stop work order, and that's a picture taken by our town manager. And that's from the north side of the lot going south towards Carolina.
Like the back to the front?
Yeah.
So the right-hand side,
And on the right-hand side is the foundation wall that was left after the demolition occurred. And what you see on that right-hand corner facing it from looking at the picture, that was built by the contractor. And we looked at it again today just to verify it, and below it, that's new building. That's totally new construction with the exception, it looks like the existing floor was left in, just the floor wood was left, sort of like.
so I think we could go,
That's
if we
all.
go to the next slide, please.
Okay, there you will see a better picture of what was built and left in place after the demolition occurred. And, you know, we took the picture, and I'm not sure whether I took the picture or Mr. Zolper took the picture, but both of us were on site.
So you've got two upright walls there, right?
That is
And it's your
correct.
testimony that those are new?
Those are new, and the substructure is new, with the exception of the existing flooring on top.
So there's new construction underneath that floor?
Yes, we looked at it this morning, the code enforcement and I, we actually crawled under and looked at it. Those are brand new joists underneath.
Okay, what does the next picture show?
The next picture just shows, it gives a view of everything, the site when we got there, of what remained. And there was no construction, and that was stopped on December 18th by us.
So, well, one last picture, if we flip ahead.
That shows some new foundation being poured in there. And it was after the fact, not when we went there initially, that wasn't there.
Which portion of, what are you referring to exactly?
If you look at the foundation cement that was poured over there, it looks like that was poured or it was dug out. I can't tell from the picture, but it was relatively new.
Immediately to the right of the old floor?
That's correct.
And is that floor damaged? Does that appear to be damaged to you?
The floor, no, the floor doesn't appear to be damaged. It looks like a new floor right over there, with the exception of the wood strips that are there.
All right, the wood surface, though,
The
is,
wood surface
is
is
old.
old. The new surface, below that, the subsurface is new.
okay. So let's go back one slide, please. So to go from what existed at the time the permit was issued to this, and again, that doesn't include the two walls that are erected, what kind of a permit would you need to pull?
It's better to explain when our code enforcement went on site and said, he was kind of taken back because there was a house there last time we looked at it. And he said, did you issue a demolition permit? And I said, I had no idea what he was talking about. I said, are you serious? He showed me a picture and I said, no demolition was issued. And the reason we issue demolition permits for numerous reasons. One, usually they're building a new house or a brand new structure. Secondly, you need to get asbestos removal or asbestos to be reviewed that the house did not have asbestos. You have to get electrical cut off and you have to have a water cut off. So that's what goes into a demolition permit, and we didn't have it. So at that point, that's when the stop.
Is there a cost associated with a demolition permit?
Pardon?
What's the cost associated with a demolition?
It's $1,500, it's a flat fee.
So your opinion is, with regard to the permit that was necessary to commence well, would you say that the work done in this instance mirrors the application that was
No,
applied for?
no.
And can you elaborate on that at all?
The work that was done was supposed to be, for the majority of the interior work, the bathrooms, replacing some electrical and so forth, some plumbing. He was going to do roof work, and that was included, but, you know, when we look at the roof work, it didn't specify tearing off the roof. I mean, just, but the plans may have shown that, but that was not part of the permit that we issued. It was basically to do roof work.
So what kind of roof work could you do short of removing the roof? What would be typical?
Typically, you put a new roofing, you get the, sort of like the shingles that you put on. Usually you take a look at that. You strip off the new ones. I've never heard of concrete, so that's a new one. But that's really what you do. You're putting you're removing the old shingles, you're putting new shingles, and you're looking for repairs that may occur in the sheathing that's below that. And that's very common to do that. It's also common that if there's doing truss work that they have to remove trusses. The responsibility falls on the contractor to notify us and to notify the county, because the county will want to take a look to see if the structure is intact. And normally, we rarely run into that. Quite frankly, we rarely ever run into this situation.
So in your opinion, does the description of renovating 2 bathrooms, renovating a kitchen, electric, HVAC, plumbing, flooring, siding, and roofing, is the work done authorized by this permit?
The work exceeded what was being done on this permit, to my head. We were under the assumption that interior work would be buffered by putting 2x4s or 2x6s interior to strengthen the roof, to strengthen the structure. And that's what we were under the impression was going to be done.
Okay, so typically we don't, the town doesn't take a position on variances, so the town doesn't appear and argue against the grant of a variance. It just relies on the board to do that. And I don't know if we're going to combine the hearing into one. It sounded like we got a little bit of a variance argument from the applicant. I don't intend, I've not been authorized or asked to oppose the variance. The variance would be for, I think it's 3 feet along the east side of the property, running, significant depth. I'm sorry, it would be 1.8
on the
feet.
west wall.
So I'm not going to speak to that, but the appeal itself is I think without merit. The argument they're making is that the house fell down accidentally, and therefore it can be treated as if it was the result of a natural disaster, an act of God. And the act that brought the house down, I'm not saying that it was intended or was malicious. None of that needs to be established in order for the appeal to be denied. It was the result of intentional acts, an intentional project to renovate this house. And as a consequence, the town did not have the flexibility to say, yes, you can rebuild that house. You've seen the pictures. That house is demolished in the opinion of the town for all intents and purposes. To do the type of work that was done here requires a demolition permit. It requires the payment of a fee. It requires the disconnection of utilities and asbestos evaluation, and none of that was done. We don't know whether asbestos was in that building, in that structure, and we don't know what impacts there are from tearing it down because it was not regulated at the time. So that's the town's position with respect to the appeal. We ask that you deny the appeal. If we found ourselves in this situation again, we would feel compelled to hold the same way and to issue a stop work order. So with that, I will take my seat or take questions.
Do you have any questions?
I do not.
Any questions? Rick, any questions?
Yeah, Jim, I was just curious, the date of the pictures versus the date of of kind of the roof collapsing. I think they said it was December 12th. Do you know what date we took those pictures? Or
They
you all
were
took those
taken
pictures?
on December 18th.
Okay.
Thank you.
Anything else?
I think that's it for me. Thanks.
And so I want to be sure that the board is clear, and while I have you up there, I just want to make sure. So if the board denies the appeal, well, if the board approves and agrees with the appeal, we're done. They can continue construction.
That's right.
If the board denies the appeal, then we're move forward to look at whether or not we approve the variance in lieu of. And that's where we are, right? So we're kind of at a two-part process. So I just want to make sure all the board members are on the same page of what we're doing here. And obviously, Mr. Dukes and their representatives can come back up and address both of those issues. But I think it's easier to kind of view them together.
Yeah.
A motion might be with respect to the appeal.
Right, and then a second motion.
To grant the appeal and to take the position that the applicant has correctly interpreted the code such that he can rebuild in its prior location. Alternatively, the town would ask, of course, that you affirm the interpretation of the town's administration in finding that this property is not subject or permitted to be rebuilt under the provision of 18559, which allows for a fallen or destroyed structure to be rebuilt as a result of an act of God, if you will. Okay, thank you.
I do have a question.
Yes.
And that is, in a case, and maybe there hasn't been cases like this, but where there is an unintentional demolition or collapse of a structure that is being renovated, does the town then seek the $1,500 fine for demolition and all these other things? Or have any of these things been done since about the shut-offs of the utilities and the asbestos contamination? Is that anything that?
I can answer that the town has not done anything. There's nothing we can do about asbestos.
Except the stop work.
We wouldn't know anything, so we have no idea that everything was turned off or the asbestos was done. Because the, whatever debris was there was cleared by the contractor. So if there was asbestos, it went into, some landfill someplace.
Okay.
Thank you for your question.
Thank you. Mr. Cripps. Our fifth member of our board has appeared. He's obviously not going to be voting on this since he hasn't been here for the whole conversation, but he's here so he can be here he'll be able to be a participant in our third hearing today. So just wanted to.
To be brief, I'd like to have Jason come back and explain a couple of the points that were made. The key to the whole thing is, we're saying it was not intentional, and I want to make it clear to the board that none of this is nefarious by any means. And I didn't want it to prejudice if you turn us down, I didn't want it to prejudice our opportunity to go ahead and ask for a variance so we could at least get this squared away. Jason, would you go over some details? Just for me, I know you guys want to get home, but.
That's fine.
we'll do it.
We have another hearing.
We have another
Still
one right
have
after
public
this.
comment to hear, so we're good.
Okay, thanks for the opportunity to speak on this. I want to touch on a couple of things. First, you just asked a question about was there any additional conversation about the $1,500 fee for a demo app afterwards? Immediately after the stop work order, I came in and emailed and have been going back and forth. We had multiple communications regarding this. I said I'm happy to pay for, obviously we can't do anything about the asbestos, but I'm happy to pay the $1,500 demo app. I also have submitted a demo application and retroactively, and I submitted also an application for the new portion of the work, which is approximately $49,000. So in addition to the permit fees that we've already paid of some $10,000 or $7,800, then we also have the additional permit fees, which we are expecting to pay for what it's going to cost me to rebuild this portion of the work. That was submit in January at some point. So the town has those. They were held, and those two applications do exist. There were a couple of things that also were stated here. I will say, based upon the application originally, it does state, and I had this back in November when we applied for this. Dawn Hinks had mentioned that she wanted this to have an engineer's stamp and seal of approval. So she had looked at the plans in great detail. We also had submit an email stating with a picture of the front of the house showing a new roof line, that the roof line was going to be raised and that the right-hand side was going to be expanded. We sent that email out, and I argued with Dawn to say this does not need structural engineering. It is an NR zone, so as an addition, a residential addition, it does not need a stamp of approval. We went ahead regardless to get the engineer to look at this and have his stamp on it to provide to the county, just to make sure that we were going to be in compliance with all regulations. Our contract says clearly framing per submitted plans. It says framing to occur per submitted plans, plumbing, electrical, et cetera. It's very clear on my documents that have been highlighted that show what walls are to remain, what foundation walls, which are the left and the front wall, to remain, and the rear and the right to be removed. It shows that those are to be removed. And as well as, the footings that have been installed, which the house was taken down, the footings were installed and inspected and approved like at the same time. So none of this, in my eyes, is new or should have been new to the county. Whether there was some oversight of when Dawn looked at this, reviewed and approved and was gone, is neither here nor there. But it does say in my very detailed 30-page contract to the county that this house is to be rebuilt, framing per approved plan, foundation per approved plan, and all that is well stated. There's a couple of things also about the removal, when you do a demo, removal of sewer and water. One, I did state that we were going to do bring electrical in. There was a tree removal permit which was done, which said that we want to remove the tree because it is a hazard to the overhead electrical lines, and we need to remove the overhead, and we're going to put underground electric in. So we had Del Power come and pull the power back to the pole. That was done and emailed about at the same time as so the electric was already disconnected. This was done at the same time. And then as far as sewer and water, we never cut into the sewer. We never had an exposed sewer pipe that's leaking. We didn't disconnect at the street. We're not doing a sewer tap. We still have the existing front of the home with the existing sewer that's in water. We never touch the water that's on site. And a final thing I would point out is that floor system photo that you see, the two walls that are erected are new. The floor system is old. They're 60-year-old joists. You can clearly climb under there and take a look at them. And Bill, I'm sorry, Jim, if you want to go, we can go over there now with a flashlight. We can get it age tested, but those are not new joists. They're not new hangers. They're all rotten. The floor system is rotten underneath there. So it would be very hard to put old flooring that's been there for 60 years back on top of new floor system. I left that floor system because you needed something to see what was there. I also have all of the old floor joists from the home, which we stored next door. So we saved those and we stuck them next door to show, hey, this is what came out of there. We have many photos of this. I just wanted to be clear on those few things. If you had any concern of what we were doing, this is not something that's happened to us before. I wish that I could get our contractor to pay for this, or who had this mistake, but ultimately I want you to know that we did try to rectify this in the proper way, and it seemed like there was nobody in place for the town who could make this decision in the interim, not having an official building inspector of capacity. So
Thank you. Does that, before you sit down, Rick, does that raise any more questions for you?
Yeah, I do have a couple because I didn't see a sewer line in there, and I don't remember spraying water all over the building as the roof came down. So was the water off, or was it?
Correct. We shut the water off regardless. The water's off for the off season. So the water is in the meter box, which is, we've got the
So you
the
turned
meter
it
at
off at the house.
the meter at the street, and then you have the water at the house, correct. So there is a water line currently, which comes into the house underneath, and it's capped, which is underneath the old portion of the floor system that remains out there.
Okay. So that wasn't damaged. None of that was damaged
No.
when the roof fell.
Not at all.
But
It's
the
all
floors
under-
and joists were, so that
They were
they
s-
had to be removed.
The floor and joists were still intact. Everything was still intact there. Obviously, we could have left that floor system. It probably should have, but
Yeah.
you know, hindsight's
Because
20/20.
I mean, I have the same question. It looks like a full demo and you left the corner, honestly, but
Well, absolutely.
I understand your position too.
Sure.
Any other questions, Rick?
No, I'm good. Thank you.
Dave, any questions? Oh, you
No,
did.
no.
That's good.
I don't have any questions.
Okay. Thank you.
Okay, thanks.
I know we have some public folks that are here to speak about this. Do you have anything else, Mr. Dukes?
No, I think that's the end of our appeal. The people that are here are basically in favor for our client to go ahead and ask for a variance if for some reason the appeal should fail.
Okay, so maybe we should do that first, discuss it. Okay. Is there anyone that would like to speak specifically with regard to the appeal, not the variance portion? Before do you see anyone online, Kate? Okay. So, I'm gonna go ahead and close the appeal portion of our public meeting. And a board I keep looking at you, but I know you're not in it. You guys want to discuss the appeal portion of this? Do you have any thoughts?
My inclination, based on hearing from the contractor and hearing from the city's officials who reacted after the collapse, and I guess back in December, is that with the legal standards that Fred has set out for us, that intentional act means that the renovation in itself was an intentional act. I would be inclined to affirm the appeal. Affirm the decision of the
From the decision of the town.
in terms of whether this 189, I'm sorry, I may not, 185-59, that it would not, that I think the town is correct in saying that this is a different beast than what 185-59 provides for. Exactly what kind of beast it is, I'm not completely sure yet. And I would like to hear more when we get to the variance, but in terms of the appeal,
You affirm
I would
town's
affirm the
decision.
decision of the town.
Okay.
Is that your motion?
And he's not making a motion, we're discussing right now.
Yeah.
Yes, any thoughts?
Oh, yeah. Two thoughts. The interpretation of intention here. The town has one interpretation, the appeal people have another. I disagree with the town's intention because in the code it says as long as the owner had no cause or reason to do this, that then the nature thing, the mother nature, whatever, it wasn't intention. The other thing is they mentioned their demolition recourse, and demolition, and I just looked it up, in construction is the science of safe systemic process of dismantling, tearing down the structures. That doesn't fit here. This was an accident. There was no planned scientific systemic demolition process here. It was an accident. So the fact they're using demolition as their key word to make this, to put this technicality in front of these guys, I just disagree with. So.
Rick, your thoughts?
Yeah, I mean, given what we've seen and given, that property, I would probably affirm the city's decision here because it does look as if it was fully demoed by accident or not. That, I think needs to some further discussion, especially given the walls that were put up. I'm not there to physically check the structure under this flooring. But I mean, given what I've seen, I would probably affirm, what the city is saying here.
And this is a close call for me, but I think under the legal language of intentionally, I would affirm the town's decision as well. So do I have, I know it won't be you, do I have a motion from either Rick or Dave about this decision, or making a motion?
Yeah,
about the decision?
I would move that we affirm the town's decision that 185-59 is not what is, that the circumstances in this case do not meet the standard of 185-59.
Do I have a second, Rick?
I would second for the same.
Okay,
And given what we've seen as the pictures and evidence.
okay. So all in favor of the motion? Rick, I'll start with you.
All in favor, aye.
Okay.
Aye.
Aye. Opposed?
Opposed.
The motion carries to affirm the town's decision with regard to the appeal. So now we're going to reopen the public meeting with regard to the variance that, and again, I'll read it. It's to permit the reconstruction of a previously non-conforming residential structure that is demolished utilizing existing foundation, including construction of the west wall extending 1.8 feet into the required 8-foot side yard setback. So I'm reopening. I'm going to let you, Mr. Dukes, go ahead and address that specifically now that we're moving on.
Thank you. This is a area variance request. It's not a site variance. This has been in, this building has been existing for a number of years. And in the course of events, I would like to ask Mr. O'Connor come forward, and he can discuss exactly what he plans and what the request is for.
Thank you.
Mr. O'Connor. He's been practicing his speech for months.
For minutes. Hi,
Good evening. Will you state your name and address for the record, please?
Daryl O'Connor, 203 Carolina Street, Dewey Beach, or 1514 Turkey Run Road, Wilmington, Delaware.
Okay, and do you swear or affirm that the testimony that you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. O'Connor, would you state the property that you own on Carolina Street, the address,
It's 203 Carolina Street.
and who do you own that property with?
My wife, Carol.
Okay, are you in the process of doing some work on that property?
Yes, we
Could
are.
you explain to the court, or
Yeah.
to the board, what is the nature of the construction?
Yeah, as has already been, I think Jason went through a lot of it. So the existing home, it's been there roughly 60 years. We've been using it every summer for roughly 30 years. When I retired last July, we decided to spend more time here, so we wanted to make a little more space. So we met with Jason, who had done some work next door, and started some conversations about what could we do with the property. We ended up with, as everybody knows now, retaining the west wall, going back 16 feet. We have a pretty good sized backyard, so taking advantage of that space and bumping out 2 feet on the east side to give us, I don't know if you've been to any of the old original 60s cottages. It was great for summer weekends and occasional visits, but as somewhere where you want to spend more time. So we wanted to expand the bedrooms, expand, well, not really expand, but modernize the kitchen and living room, open it up a little bit to open the space up. But essentially, we were keeping, and Jason went through this with me, it was very emotional for me to change the whole house. We're keeping the same one-story cottage look. It's mostly, and the same basic layout. It's just more space, more bathroom space, a full-size bath instead of a toilet and a sink, if you've been in any of that style cottage before. So a full bath for us, a reasonably sized closet, and then more room for guests if people come to visit. The bedrooms aren't quite so cramped.
Now, Mr. O'Connor, are the neighbors familiar with your plans?
Yes, they are.
Okay. Now, the nature of the neighborhood, how would you describe that?
It's, single family residential.
And the use in the neighborhood and the character of the neighborhood, is it all single family? Is it?
Yeah, all single family, and I don't know if you're familiar with Carolina Street, especially that part, but it's the one where the Shell Street is. So it's primarily, if I go round, it's primarily owners using it, not a lot of rentals. And, yeah, it's residential.
Have you talked to the neighbors about the effect that your structure would have on their houses in the neighborhood?
Yes, we spoke to, on both sides, which would probably be impacted the most. So 205 on the west side, we've spoken to her, and in the packet, there's a letter from her, from Grace. 201 on the other side from Kelly. You've got I think you have the packet, I forwarded it. There's a letter from Kelly on the other side, also stating her basically not have an issue with what we're doing. And then some other neighbors on the street with just confirming that they don't have an issue with it.
And do you think that this new house will have an adverse effect on the neighbors?
No,
You think it will improve the neighborhood?
absolutely. I mean, the original house was fine. This one will, it'll be, well, let me put it this way. For the most part, all around us have done some renovation. We've done very little in the 30 years we've owned it. So this will certainly improve the neighborhood.
Now, if you're not granted this variance, what would happen? How does it affect you?
Well, before we get into like this, the first thing is if we delay this longer, we've got a good bit of money tied up in essentially low interest. So that was set aside for cash so we could pay progress payments. That money has been sitting in essentially a low interest account since December when the construction started. So there's a hardship with that. There's a hardship with starting over. So there was a pretty significant amount of time we spent with Jason coming up with this final design. So if we got to go back to the drawing board to redo it, it would go quicker, I think, quite honestly, because we've got some basic ideas. But to shift the whole thing over, we're starting that process over again. And I don't know all the construction lingo, but I would think there'd be some additional expense to going back for permitting and things like that. Also, kind of unrelated, but I've already resigned to the fact that we've lost the use of the home for the summer. So I've got some additional expense. We're renting a couple places through the summer so we can get here and at least enjoy Dewey in somebody else's house. But not a hardship so much with the construction, but I don't really want to spend my summer in Wilmington if I don't have to.
Gee, I don't know why.
I've been coming here, well, counting rentals and group homes, we've been coming here since mid-'80s, I think, correct? We rented a couple places in George Street. We've been on Carolina Street for a little over 30 years.
Do you think the construction of this structure will improve the neighborhood and the character of Dewey?
Certainly, and I think mostly because our design decision was not to build a gigantic, fill every inch of the lot, multi-story. We wanted to keep it single-story cottage. So if you, and the plans were up, and sadly, I guess you can't see the original house, but it's the same basic style. It's a small one-bedroom or one floor cottage with modern bath, modern appliances. Again, some of the things I joked with Jason about when we were first talking to him. The electrical system in it was original. There were switches in the house that didn't work. Sometimes they did, sometimes they didn't. So it's mostly to make it, well, one other thing I left out is it's one of the homes that was intended to be all season. But for example, we still have the original propane heaters that hung on the wall. So if we came in the wintertime, you had to leave all the bedroom doors open or bring in space heaters. So it'll be nice to have, this is basic stuff, right? It'll be nice to have normal heating, normal air conditioning, things like that. It'll be a more usable, well, there it is. So it's that front porch on the right in that upper left corner is exactly where the current porch is, just a little bigger. That's the original living room window there. So the basic layout, this is more elevation stuff, but if there's a picture of the layout, Yeah, I need it with the rooms, there we go. So all this stuff, when you look at the layout, the kitchen is where the kitchen is now. The porch is where the porch is now. The living room is where the living room is now. It's just bigger. The stuff in here is all give us a reasonably sized closet, a master bath, a larger master bedroom. The other 2 bedrooms in the back are essentially, there's still 2 bedrooms there. They're just bigger now, but now there's a larger bath. And then the other is a utility in the back, so that when you come in the house, you can rinse off sand and stuff like that before you actually enter the house. So the basic layout is the same, a little bigger, but the same. Our no intention to go big and have, several, multi-thousand square feet. So I'll shut up now.
Does anybody have any questions?
Any questions, anyone? I don't think so.
I'm good.
All right?
Thank you.
Yeah.
We have received several letters in favor of granting the variance to allow this 1.8-foot side yard setback. I'm not going to read them word for word, but basically all these are in favor of that it won't affect anyone negatively. I've got a letter from Brian Kerr and Grace Corradino at 205 Carolina Street, Alicia Farley at 200 Chesapeake Street, Kelly Henderson Kendall, 201 Carolina Street, and Marcia Scheck and Richard Greenfeld at 201? Yeah, 201 Carolina Street. So those are the letters that we've gotten from the town, all in favor, or sent to the town in favor of this variance. Is there anyone in addition that's present here in person that would like to speak on behalf or in favor of the variance? Is there anyone on, oh, yes.
I would also just say there are 4 others that are not, that you didn't list, that are in our packet. There are 4 other letters of neighbors who are also in favor of approval on that.
Thank you. I've only got the one. I appreciate that.
Yeah, Julie, there was a few that he submitted with his packet. Anything that came in after the fact is that separate packet there.
Okay.
So you have them, they're just separated out.
There you go. Yes, can you do that?
Yeah, there's a letter here from Jeff Werner and Claudia Sons Werner of 206 Carolina Street, saying they're in favor of this. There's a letter from Carrie Tolucci at 121 Chicago Street, also in favor. There's Abraham Birch at 200 Carolina Street, who's in favor. That's all I have. There's actually,
Thank you. So there's no one here in person. Is there anyone on Zoom that would like to speak? Kate? No. Okay. So, and I'm guessing by everyone's silence, there's no one that would like to speak against the variance? And I'm assuming, are we still no crickets from people online, Kate?
Correct.
Okay. So at this point, I'm going to go ahead and close the public meeting. Thank you, Mr. Dukes.
Thank you.
And we can discuss, everyone but Dave. We won't leave you out in the next one.
Okay.
Rick, any thoughts?
Yeah, I mean, and I agree, we're not setting precedent, but I would remind the board that this is the second board meeting that we've had where a builder has made a decision and done something that affects setbacks and then asked for, for Board of Adjustments to pass a variance. I just, and maybe this is more for the town, but somehow we've got to get to a point with builders that they shouldn't be asking for forgiveness. They should ask in advance. So, but other than that, I mean, I see, I've read through the letters and it looks like all public comments are positive. Yeah, I think that's it for me from a discussion side.
Dave? Any thoughts from you? Any discussion?
Yeah, again, I mean, I do have, I think, a better sense of what happened, and I understand that this was not, or it's not no proof that this was any sort of malicious act or anyone trying to escape or evade compliance with the town's regulations. I do accept Rick's point that this is the second time in the last few months that we have had a case where there has been something that had happened, and then asking for after the fact. But in this case, I mean, the owner has made his presentation, which I thought was very effective, and he certainly has brought forward a lot of the neighbors. So I think going back to the standards of whether it's consistent with the district and the character of the vicinity, I think we would have to agree that it is. Whether it's an exceptional practical difficulty that if we were not to grant the variance, he has certainly made a case for that as well, that there are both time, economic factors, and others. And as I understand it, and again, if correct me, someone I hope will correct me if I'm wrong, we're only talking about a variance of 1.8 feet into an 8-foot setback, which, regardless of what foundation was there, does pre-exist. And so in the sense that this is breaking new ground, it's doesn't, at least I do not see that is the case by they're going further into the easement than they previously had. So in that sense, I would be inclined to favor the variance, because I think it would work a hardship on the owner, and having the owners pay for what was a mistake by the contractor, not necessarily saying it was negligent in any way, but certainly the claw stuck in the roof is not something, it's something that seems like should have been avoided. And then to go forward with demolition as that happened without, I guess there was notification, but it was somewhat after the fact. I think it's problematic, but I would be in favor of the variant for the reasons that I've given.
I'm in favor of the variance, just they meet all the criteria. I don't see any
Well,
exceptions there.
I see a difference here too, because the footing is the same. It's always been 1.2 feet inside for as long as the house has been there. The accident didn't happen and then they said, oh, we need even a bigger variance. We just want to go along with the plans that we have. So I definitely would say I'm in favor of approving the variance as well. Do I have a motion?
I motion to accept the variance, approve the variance, whatever that is.
Reasons stated.
Reasons.
A second?
I second.
I said, okay.
Okay. Okay, well then I'll start you with the vote. All in favor? Rick?
All in
Start with
favor,
you.
yep.
For,
In favor for the points that were made by David there. I think it does stay with the character of the neighborhood. I think that, it's within zoning. And then, practical difficulty, I have a little difficulty with, but I think there is some practical difficulty impeding trees and other neighbors if we have to recenter this house in the building envelope as it were new construction.
And for the reasons that I've previously stated and the ones that Rick just mentioned, I thought the information about the trees and not wanting to sacrifice the trees in furtherance of the construction is certainly another reason to grant the variance.
I agree with that.
Okay.
Yeah, I'd be repetitive to say that.
Right, I understand. So yes, I also vote in favor of the variance for the reasons previously stated. So that is a unanimous vote by the board to approve the variance on this property. Thank you, everyone, for your time.
Thanks.
So I'm gonna let everyone shuffle out for a minute and then we'll get started on our third application. There's a water, like right around.
I'll be right back.
Nice meeting with you guys. Thank you, guys. Good to see you. I think it was right for you guys to reject that narrow reading. I think it was right for you guys to reject.
What narrow reading?
Of the appeal.
Yeah,
Yeah.
it's a tricky one.
Yeah.
All right, you guys take care.
Thank you, it was nice seeing you.
And you know now the town is gonna make it so that there are supposed to be trees on your property, at least 3.
Started back on our hearing number 3 for 24 Dickinson Avenue, Unit 9A. It's a request for a special exception to permit the structure located at the southeastern corner of the lot to be recognized as a residential rental unit. The request has been submitted by Mr. Dukes, legal representative for the Dewey Villas Condo Association. So I will let you go ahead and get started.
Good evening. For the record, my name is Hal Dukes from the law firm of Tunnel and Razor. I've been working with this particular site. I've been practicing law for 54 years or 53 years now, and it's been most of the time. It's interesting about this. Jim Dedes has dedicated an entire year of his life to this. He could probably write a book on it. But where we are is, where we are, and you know, this has been a puzzle for everybody. The unit was built before the Dewey Beach Code existed. In the course of events, it was during the Wild West days of Dewey Beach, and the homeowners association had problems there. And so what they decided to do was to allow somebody to stay there because there's a swimming pool. And one of the things they used to do is get in the pool after closing hours of the bars and stuff like that. So they had this available for a lifeguard is working for the state, or you know, policeman, a summer cop, something like that. And the operation here, the way it's set up, the group, or the ownership is owned by the condominium association. And they, over the years, they've been trying to be good citizens, and they come back and they bought a license to rent the unit. The rental's not very much. In fact, it's the cheapest rental in the state of Delaware in the ocean block. And I think to qualify, you have to, you know, have to be a lifeguard or something like that on a budget. The unit's very sparse. It does not have a stove, by the way. It's just living quarters. And in the course of events, they went in to get the permits or the license, and they said, well, no, it's now you don't qualify. And so we started this process 5 years ago. And it was decided that what we would do is apply for a variance. And then Dawn said, well, you can't get a variance until you get 100% of the board to agree to it. And it has to be every single owner of the units. So David Brandt, who is the president, has spent the last 4 years campaigning, getting everybody to sign. We could not make an, and this has been on the agenda for a couple of years, but we kept pushing it back because we had one holdout who just basically didn't get along with anybody. And so she finally sold. And the happiest day of David Brandt's life was the day they closed, they settled. So in the course of events, here we are. And so now we're making a continuation of our application started 4 or 5 years ago. I'd like to call Mr. Brandt first and for a few questions, and then we have the secretary or treasurer. I guess you're the treasurer, right? Vice President, okay. Yeah, we'll go over the process of getting the permits. David?
Oh, I'm sorry. Name and address for the record, please.
David Brandt, 902 May Lane, Stevensville, Maryland.
Mr. Brandt, you solemnly swear or affirm the testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Mr. Brandt, are you familiar with the property known as Dewey Villas?
Yes, very familiar.
And what is your relationship to that?
I'm currently the president of the Dewey Villas Condo Association, and I've been an owner at the Dewey Villas since 1993.
Are you familiar with the, we'll call it the pool house, the unit, we'll call it 9A for lack of a better term?
Yes.
And is that located on the premises?
Yes, it is.
And who owns that unit?
The condo association owns it.
And what have you done with it in the past? Has it been occupied by people during the summer?
It's been rented. It was actively rented at the time I bought in 1993. Lifeguards have been there, security, town, summer seasonal workers have been there. It's changed a number of times, but it's always been a seasonal rental.
And how expensive is it?
I think the last time we charged it was somewhere in the vicinity of $5,000 for the season.
And if you were looking for a person to occupy the premises for the summer, how do you get that tenant?
We do word of mouth, but we would also, we have discussions about it to have someone, either a lifeguard, law enforcement. I mean, I love Dewey Beach, so if it's something that we can make a couple of bucks for the condo association and a convenience factor for the town, we're certainly all for that.
Now, if the summer cop occupies the unit, does he have other responsibilities other than just stay there?
We would ask that in return for staying there, that obviously, as Hal touched on, it's a pool, and we do want to keep, it doesn't happen a lot, but it has happened occasionally where people want to jump in after the Nalu closes down or whatever, but the idea would be for them to keep an eye on things in the off hours, particularly overnights, weekends, that type of thing. And just to let us know if there's any issue or any problem. I don't want them to actively act as confronting anybody that might be there.
Now, can you describe the unit in question?
It's a cute, small unit. It's got a like a bedroom, living room combination, full bath, small kitchenette area with microwave and a refrigerator.
Is there a stove in there?
No, there's not a stove.
Okay, so they're going out to eat every night.
Whatever they choose to do.
What's the nature of the zone where this is located?
With the condo association, we share a property line with Nalu. It's formerly the Bellboy is behind us. It's under new ownership now. Hyatt's across the street on the bay side. The Gold Leaf is across the street on the other side of Dickinson. And there's other condo units, et cetera. I think there's might be a single family or two.
So, describe the character of the neighborhood. Is that high density?
I would say yes. It's not a residential type area. It's multi condos, hotels, businesses.
Has any improvements or changes been made to this particular structure since the building was built in the 1970s?
No, we haven't changed anything. Basically, obviously, paint and maintenance and that type of stuff.
Are the neighbors aware of this particular application?
Yes, I believe they are.
Has anybody expressed any concerns about this application?
Not to my knowledge, no.
What would be the effect if for some reason if this application were denied?
It just takes away, I mean, I don't see a downside to it. It's not life-changing for the town of Dewey Beach, but there is some rental income to be made. It is a place for a seasonal type of person to spend the summer and affordable. And it gets some extra income for the condo association for maintenance and repair to our primary building and the pool.
Do you have any questions, folks?
I'm assuming the answer is no, but just out of curiosity, is there a parking spot reserved for whoever rents the unit?
Yes, there is.
Okay.
And the drawing that's on the back of your letter, is that a drawing of the unit 9A? Floor plan?
My official sketch,
So it's about 250 square feet or something?
I would say approximately.
Mr. Brandt, one of the questions I have is, there was an amendment done for the declaration. Did all the people sign that, every owner?
Yes.
I think you have a copy of the amendment in the record today.
How many, just refresh my memory, how many units are in?
Well, that's what's strange. There are 16 units there, which grossly, if you take that number, you multiply it times the square footage, you're looking at something that is well beyond what's established by the code, the city, the town code here. And in that regard, that's where I guess the variance is for. Let's see, I think you have pictures of it. You stand on that. Do you have some pictures there?
I do.
Does anybody have questions on these pictures? Mr. Brand has pictures and you can go ahead and.
It looks like the
Yeah.
same.
Okay, well, perhaps you can just tell us what you're looking at here.
That's standing in the parking lot, looking, the pool would be to your right out of the picture, looking at the unit from that angle. That's looking from the street. You can see, you can barely see it from Dickinson
So
Avenue.
it's in the very back of the parking lot.
The very back of the parking lot, yes,
Is
correct.
that where you park the cars?
Yes, right alongside, there's two spots right alongside of the unit. And they don't, no cars are allowed to stick past the structure itself, so they're nested in there.
And this is,
This is looking towards the Hyatt. Ocean's at my back. Bay is past the Hyatt, of course, and that's the condo building, main building. And then you can see part of Nalu, also right past the building. And that's looking from, look, I think that's my, yeah, it's my deck, looking down to the pool and the structure, the pool house structure right there at the end of the pool. Basically same. And from parking lot level, looking at the same, in the same direction as the pool house. Street view, yep. And that's standing, looking from towards Dickinson, the back of the main building of the condo association, and the pool house. The pool obviously would be to your left out of the picture on the other side. And again, looking towards, from the parking lot, looking towards the unit. And again, very similar. And you can see one of the two parking spots.
one of the questions that I've forgotten to ask, does the pool house or the building share storage with the pool supplies and things?
There's a corner of the structure is the pump for the pool
Now,
and filter.
who handles the maintenance and chemicals and everything for the pool?
We have a company that comes by daily in the summertime.
And is there any chemical store on the premises?
No, not on the premises.
Any questions, guys?
So maybe at this point, before they sit down, we could talk a little bit about what the variances are that they need, because this is not,
This is not our typical.
this is not typical.
Great.
Right, I was gonna ask you that, actually.
And just in case that discussion leads to any questions, they could be put to the petitioner. Ms. Banaszak, can you pull up the Dewey Villas condominium declaration plan? Mr. Duke said that they would like to amend that plan, and you've been sent a plan. But this is the plan currently, and could you expand it any further and try and hover over the unit? Okay, so you can see the pool there, and I think you can see that what's referred to as a unit or Unit 9A is described as storage area on the plan. Yeah, there we go. So that's what it is as far as the code is concerned. The applicant would like to convert that into something other than storage area, of course, and make it a dwelling unit. And that calls into question there's some additional elevations there. You've seen pictures, but those are additional elevations that go along with the plan. Could you also pull up, Ms. Banaszak, the table 2? Looks like, yeah, there we go. So that's also very small print, but page 4 of table 2 includes a reference that Mr. Dukes spoke to. And that's a calculation for how many dwelling units you can have based on the square footage of your property. And I believe the square footage of the property, you see maximum dwelling unit there on the left, right there. To the right, one dwelling unit per 3,600 square feet of land area is what's permitted. This parcel was described to me by the former building official as being 175 feet by 125 feet, or 21,875 square feet, which would allow for about 6 units. And there are 16 units on the site right now. So there is a density restriction. Obviously, the 16 units are legal, non-conforming, but adding any additional units would be prohibited absent a variance. Secondly, I think, Ms. Banaszak, you might be able to find that section 18560, which prohibits the expansion of a non-conforming use or building. 18560 indicates that a non-conforming use or building may be expanded under certain conditions. Those conditions are, one of the conditions in question is whether the expansion would be within the maximums for square footage, for number of bedrooms, floor area ratio that are applicable to the property. So we know from looking at table 2 that they can't expand in compliance with 18560, so they need a variance from 18560 as well. So it's the density issue in both cases that prohibits what they're seeking to do without a variance. If this variance is approved, they can file a new declaration plan, and the county will look to the town as far as whether what they're proposing is compliant with zoning. And if the variance is granted, the town can indicate that that can be a dwelling unit. I don't know if there are any other issues that are raised for the town in terms of, I mean, obviously for it to be rented, there has to be a license issue.
Yep.
Also, I would say that in consideration of the application, it's not really going to be a factor who rents it or what qualifications they have or what jobs they possess on site. It's not irrelevant, but it's not a big consideration of yours.
Correct.
Question, Dave, out of the last 30 plus years you've been there since 93,
Yes,
how many years have you actually rented, not years, but seasons have you rented that?
it's been every season.
Yeah.
We've gotten rental licenses from the town numerous years.
I live across the street, I've been in the unit.
Okay,
I'm
yeah.
familiar with it.
Yeah, okay, yeah.
Yeah. Fred, does that have any weight as far as, because the town came in with this variance, I mean, this zoning stuff after they had already established a rental history there?
Well,
I'm just asking how.
I would say that the town, the unit itself that they're describing as Unit A or 9A is labeled a storage area. So I don't think the town had a duty to or failed to meet some responsibility of its over the course of this year, because this has always been labeled storage facility.
So all the years they've been buying a rental license, I mean, I thought the town would know what they're renting and what's not, and compare to the, you know.
I don't know how many years. Do we know how many years they've gotten a rental license? I mean, they were denied a rental license recently.
Yes.
That's, no, I don't know the exact amount, but
The treasurer here.
I have the information, more than 10 years.
Well, I would say that, people contact, we don't have a duty to, the town doesn't inspect rentals. That's been something that has been kicked around, and the town doesn't place a seal of approval on the conditions of a rental.
I was just asking, I wasn't saying,
Yeah.
in favor of that. Just
Yep.
asking.
Just a question for the applicant, if I could. Do you have plans to renovate or enlarge this? And then would that change any decision or need for a different?
No, it's a cinder block structure. It's going to remain as is. Obviously, if we're able to rent it, clean it up and paint it, but that's happened over the years as it's been rented out anyway.
And then maybe this is for Jim, but does it meet sort of the residential standards for inhabitants? And I think Fred just mentioned we don't inspect, but is there anything like that?
No, the rental license itself has a whole list of requirements by whoever owns it and rents it out, that they're responsible. Fire, having smoke alarms, making that the electrical outlets are up to code, so forth. So it's predominantly a self-inspection, and the onus goes on to the property owner to make sure that they comply.
Okay, thanks.
Any other questions?
Well, just so I understand, there's 16 units, and so that's 1 through 8, A and B, make up the 16, this
Correct.
is 9A. Okay.
Yes.
And of those 16 units, did they also vary in how large they are? Because I saw that there was a list with different percentages of.
Yes,
ownership in
the B units are larger than the A units.
Okay.
I don't know the actual square footage.
And are most of them rented during the summer, or are they?
It's a combination, it truly is. Some of the owners do not rent their condo out, and some do, and then there's a mix of, I rent out for these 2 months. I mean, I personally rented July and August, mine,
Right.
but we're there and we're here for the month of June, and then in the spring and fall.
But all the rest of them would have kitchens and,
Yes,
okay.
yes.
One of the things that got us into this was because it does not have a kitchen, it really isn't considered a dwelling unit under the code. And, but the homeowners association felt it was appropriate to take one for the team and go buy a rental license. So in theory, and the other thing she asked, can you change the size of this unit? No, you have to do a declaration, change your declaration. Of course, I guarantee you folks wouldn't allow this to expand. So that's pretty sure. But even do the deck plan, you have to get everybody to agree. It's taken us 4 years to get these 16 owners to agree that we can come here tonight.
So to get 16 people to agree that the sun's going to rise in the east tomorrow.
No, me either.
Anything else from you, Rick?
I'm good, thank you.
Did you want to say anything, ma'am? Or did they cover everything?
I don't hear what you're saying.
Did you want to say anything? I'm sorry.
When you were speaking, they asked for the square footage each floor. They were originally built as 8 townhouses.
Okay, you need to,
Yeah.
you need to get it in.
So name and address, please, for the record.
24 Dickinson Avenue, Unit 3A.
And your
Suzanne Evans.
Ms. Evans, do you solemnly swear or affirm the testimony given in this proceeding will be the truth, the whole truth, and nothing but the truth?
I do.
Ms. Evans, are you an owner in the Dewey Villas?
I am.
And how long have you owned?
Since 1999.
During that period of time, were you participating in getting the rental license for this property?
Yes, I was treasurer at the time.
And did you pay every year?
Yes, I did. In fact, I received one. I brought it with me for this year.
Okay. And the reason why they couldn't rent it last year was because you could get a rental license, is that correct?
That's correct.
Okay. Do you have any other questions, folks?
Well,
You were saying something about square footage?
Yeah.
Go ahead. You finish your thought about what you were saying. You were saying something about the square footage?
the square footage, they were originally built as townhouses in 1974. They were converted to condominiums in 1984. So each floor is 600 square feet.
Gotcha.
3 times.
Okay, thank you.
Sorry.
Anything else from anyone? I don't see anyone else in the building with regard to any comments. Do we have anybody on Zoom that wants to speak on behalf or?
Yes, I'd like to comment.
Yes. Fred, we have someone.
Oh, okay, thank you. That's Ms. Scheck.
Yes, thank you.
Name and
So-
address, for the record.
Yes, Marcia Sick, 1430 Bayard. is
Ms.
what
Scheck,
we're,
Ms. Scheck, do you solemnly swear or affirm the testimony given in this proceeding will be the truth, the whole truth, and nothing but the truth?
yes, of course. I'm trying to understand what we're trying to approve. Are we trying to give a variance for a unit that is within the front yard setback to be an occupied unit for residency?
I don't know if it's in the front yard setback. What we're entertaining is a variance from the density requirements to allow for an additional unit to be located in that complex.
I'm looking at it. It's right beside the pool. It's been labeled storage. How do we know what are the setbacks and does it meet them?
Well, the structure's been existing there for longer than the town exists, right? I mean, so the structure itself.
74.
The structure itself is legal non-conforming. The question is, it's not being expanded, but the complex is being expanded by another unit if the variance is approved. So they're not asking to build anything in a setback. They're asking to repurpose a storage unit as a dwelling.
Correct, but I'm asking, is it in any setbacks?
We don't believe so.
Fred?
I don't know. I don't have dimensions for whether it's in a.
I'm not sure how we can make that judgment then.
Well, it's a legal non-conforming structure.
Correct, but we're repurposing the use from a storage building to a full residential building. And I just want to understand what we're asking for. What are the setbacks for the building to conform a storage building, which is permitted by the code to be on any lot at 3 feet from any property line that is non-functional use for living purposes. So I think it's just really important we understand the parameters of what we're allowing.
Well, for instance, if you look at the units on the plot, I believe that a number of them would be non-compliant with side yard and perhaps rear yard setbacks.
Correct, and I agree with you. And they remain their original structural conditioned use, which is storage. But now we're asking for a storage unit to be converted legally to a residential structure. And I think we need to look at what are the code requirements of setbacks for a legal residential structure. Does it meet those code compliances? And I think if it does, then we move forward. But I don't think you can consider this application without looking at the setbacks to change a storage unit to a legal structure that doesn't meet the setbacks.
Well, from looking at the plan for the condo association as a whole, it looks like, the way I'm reading it, it looks like since it's enclosed on the property, it does look like it is, let's see, what does that say? It's hard to read this. It's 6'9", 6 feet 9 inches from the neighboring property, Emerald Shoals.
Well, is the parking in the back there in the vicinity of the pool in our condominium complex? Yeah, so I don't think the structure is anywhere near the rear yard boundary line. And it appears to be a very significant distance away from the side yard. In fact, the neighboring parcel to the left. Yeah, so.
I'm just asking, do we have the dimensions?
Yeah,
Because I think it's really important when we're looking at code issues that and we're considering a variance, we have the dimensions of what we're asking for with a variance.
Well, and that's what I was just looking at, that it looks like, based on where the building is, it's far enough back within the property line that it would conform with setbacks.
Brett, just so, yeah, I'm just trying to figure out, are there any other things that we need to consider moving this, like Marcia said, and you mentioned from a storage unit to a residential unit, other than density and possibly setbacks? Is there?
It was
anything
never,
to
it was
consider?
never a storage. It was never used as storage.
Right.
It always had a kitchen, a bedroom, and a seating area.
It has a kitchen but not a stove.
It has a kitchen without a range, right?
1974, a microwave and refrigerator.
Microwave, refrigerator, kitchen sink, full bath, bedroom, and seating area. It was never
I
used.
guess my one question is this a single separate unit?
Yes.
Yes.
It's a structure that is independent.
I've seen it.
Okay, we're gonna have one conversation at a time. So,
Well, I would guess that's considered an accessory structure to the building.
perhaps, yes. I mean, it's a storage structure. It's it's not a dwelling as the Dewey Villas condominium was recorded. It is labeled a storage area. It may never have been used as one, but that's what it's labeled as. It is not labeled a dwelling unit. So here we are. It's a very, very unusual
And I think it's quite unusual, but I think as more and more property owners choose to build more accessory structures in their yards, meaning they're building outdoor kitchens, outdoor summer kitchens, pergolas with kitchens, full kitchens that we don't allow. And while I understand and appreciate that this board believes that we don't set a precedent, I believe, just my opinion, we actually do set a precedent when we start to allow structures that violate the code to exist on special circumstances. And I think our code is very clear that an accessory structure that was limited to a storage unit that is now going to become a residential unit is not compliant with our code. And I think if we permit this, I love that. I honestly love that because I believe more and more property owners that buy ground, dirt for $2 million and want to build a house for $2 million want to have outdoor enjoyment areas that include outdoor kitchens, outdoor spaces, partial guest houses. But I do believe, and I think we should approve this, but I think if we do, we should also approve other property owners and change the code to just simply allow accessory buildings that are part of the main building to exist as functions of the main building for auxiliary living space. And I think that's really what we're doing here.
Well, that's a whole nother discussion for changing the code is a whole nother discussion for a whole nother day.
I'm just saying, let's just abide by the code.
Okay, thank you. Is there anyone else on Zoom that would like to speak? Kate?
No.
Okay.
I'm speaking up.
Okay, well, at this time then, I'm going to, unless anybody has any more questions, then I'm going to close the public hearing with regard to this matter. Discussion.
It's always been a residential area. They've rented it for years. And because, what happened? Why did they get denied?
Because it's technically not.
Somebody found
They
out?
need the variance.
Somebody found out that it wasn't? Okay. I mean, but they've been renting it for,
When I look at it, just because it doesn't have a stove, like, I look at hotel rooms that have a hot plate and, they're still considered dwellings just because they don't have a stove.
Right. And it was built before
Yeah.
Dewey Beach was incorporated.
And used as that before it was
Right.
as a rental unit.
So, and to her point, we do not set precedents, you know. If it's
Case
some-
by case. It's case by case.
I think that's a question.
Ms. Streck, the public hearing is closed. I'm sorry. Rick, do you have any comments?
No, I'm just, I have this, is there anything else we need to consider making this accessory building, storage unit now, residential? I think, what Dave said, it's been a residence in practice for a long time. It's now come up that, they need to actually call it a residence so that they can rent it, but it's been rented for a long time, so, yeah, I don't know how they changed their condo docs to then reflect that it's residence versus storage unit. or
I think-
part of the whole process.
Yeah, the official variation is because of the occupants, or no, the density. That's what I was looking for. Thank you, that was the word I was looking for. Sorry, it's getting late. It's been a long day.
So if we approve the variance, then they have to go to the town to renamed?
I believe the process would involve them filing a new declaration plan which relabels that
It's
site.
for storage.
And our variance, if it were granted, would be from the density restrictions in the table to allow 17th unit on a parcel that is.
For 21,000 square feet.
Yeah, which permits 6 units under the current code. So that's the code restriction that's an issue. Now, I don't know presently as we sit here, and I don't think it's totally relevant, whether there are housing standards that they've got to comply with. But they have to comply with those regardless.
In order to rent it.
Yeah, so, if there's no reason for us to assess whether the unit is a suitable house or a suitable dwelling until after such time as it gets relabeled.
Okay.
And if the unit is not compliant with housing standards, they can't rent it, even if
Right.
it says.
If we say we can, yeah.
Even if it's labeled a rentable unit.
Well, it's kind of like.
It has a long history of being rented, but it has a long history of being labeled storage.
Yeah.
Right.
So it's not like we changed the code to outlaw
Well, and
this.
I compare it to when we are looking at variances for building plans, the town still has to approve the plans,
Yes,
regardless of
that's
whether
right.
we allow the variance, they still have to go through the process. So obviously, the condos are still gonna have to go through the permitting process if they wanna rent it.
Right.
All those things that
Right,
are
this is just
outside,
step one.
this is outside, that stuff is outside of our purview.
Yeah.
So. Do I have any more discussion? Does anyone want to make a motion? Anyone?
I make a motion to approve it.
Okay. Do we need to go through the quick?
Yes.
We still need to go through the standards.
Okay, criteria?
Yeah.
I didn't see any violation in the conversation we had, and I know, the
The residential area.
So, yeah.
character meets immediate use of the, immediate vicinity use. It's not,
What impact does it have on neighboring properties? Well, that's for you to say.
yeah.
So you think it has minimal impact
Right,
on neighboring
I've
properties?
had my house there, my townhouse for 20 years. I've lived there for 6 years. And when it's rented, there's no, the traffic on Dickinson Street in the summertime is, one more car, and they have their own parking, which is a plus for them. So they're not,
Now, having said that, what is the applicant's exceptional practical difficulty?
Yeah, that's,
What is the difficulty that they're confronted with that justifies a variance from the code? There's a monetary loss apparently.
not a lot, but yeah, that's a consideration.
I don't know if I heard
There's a
anything,
potential safety issue because they tend to.
For the
have
pool.
People, yeah.
but yes, there's no requirement in the zoning code that says that people who live in particular units are required to have qualifications and provide for
Right.
safety.
So contribute to the community or anything like that.
Mhm.
I don't know about the hardship thing, that's the tough one to consider. Again, the town's been acknowledging them as a rental unit and paying, taking their money for all these years, which is like an acknowledgement, and all of a sudden it's like, no more. And I don't know what brought that up or who said, hey, we can't do this anymore. The density thing though, again, I mean, they're out of compliance with density, but they have been ever since the building was built. I mean, ever since the town of Dewey Incorporated is when they become non-compliant to the density or non-conforming to the density because it's already there like that. And I don't know, it's not a new structure. It's already been laid out, a little apartment type thing for 30 years. And now all of a sudden it's like, no, can't do it anymore. So the hardship is the one, you have a point there of why not to. But
Well, the hardship would be the loss of income.
loss of income, that's the only one.
And what do you
I
do
think
with
of.
the income? You use it for,
Well, we
Maintenance.
can close.
oh, I'm sorry. So they use it for the condo association, so that would be the hardship.
Well, and the hardship, and on the flip side of that, then the other condo members don't have to pay, maybe their dues are not as high based on the fact that they're getting this rental income.
Right.
From it. So those keep going up.
Yeah, they always do.
Anyway, is there a second for the motion?
A second,
Dave, second, for the reasons listed.
for the reasons, yes.
So I'm gonna put this to a vote, go around the table. Rick, we'll start with you. In favor, opposed?
In favor, I think, yeah, I think it keeps with the character of the vicinity. It's been there for, gosh, 60 years. Yeah, it doesn't impact really the neighbors. Again, it's been there for a while. We're finally, defining it and legally recognizing it. So I think that's kind of the right thing to do. It's that area is also zoned residential, right, and high density. The practical difficulty I find is just the rental income. Yeah.
Thank you.
So, yes.
In favor or opposed?
Favor,
Okay.
in favor.
You've already stated your reasons
Yes.
based on your motion?
Yep.
Dave?
I have not said my reasons. I think that it is consistent with the district and the character of the vicinity, because this is many non-conforming uses in this area and very dense, most of it. I think that Rick's point about historic usage and that it's not really changing an existing use, it's just a legal recognition of one, is significant. The exceptional practical difficulty, I guess, is where I am stuck most. But I think it does meet the factors. I guess what, in my mind, and Fred, if you still can address this, we are giving a variance for two regulations, the density as well as.
So it's two regulations, but the second regulation I mentioned is a reference back to
the density,
to the
and it's
density
basically
in the
the-
table two.
Right, okay, all right. Okay, well, the variance, I guess I think that if it is clear for what specifically we are doing, then I can be in favor of it.
So you made the motion, so are you in favor?
Oh, yes.
For the reasons you previously stated?
Yes.
And I also vote in favor of the variance for the reasons everyone has mentioned. And so that means the variance has passed unanimously. And is there anything else we need to cover? Before, one last item, it's not on the agenda, but we were discussing another meeting. So before we go, everyone can look at their calendars. And And we're looking at an April 30th at 6:30 PM.
6:30?
6:30. Randy's got
I want to
a
be,
appointment, so we're gonna give him a little extra time to drive here.
it's a 3-hour
from up
drive to
north.
get back here, I can do it
From
though.
up north. So,
I cannot be
yeah, you
here,
said
but I
you
could.
could do Zoom.
Yeah, I could do Zoom, I think. Let me just check.
What about you, Rick?
Checking now. I am fine.
Okay, so April 30th at 6:30?
Yeah.
And that was the date, the 30th was the date that the attorney said, correct?
Mm-hmm.
Okay, so,
I think that may be the day I'm going to attend,
I'll
I'll see if I can,
It might be
if I can make it, yes.
Okay, well then go ahead, we're gonna go ahead tentatively right now set our next meeting for an appeal, another appeal issue on April 30th at 6:30 PM. And that note, do I have a motion to adjourn?
Motion to
I
adjourn.
motion to adjourn. Second.
I'm gonna call you second. All in favor? Aye.
Aye.
Okay.
Thanks, everyone.